Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about not quitclaim deeding your real estate to your kids. Before I get to that, I want to remind you, if you have questions about this or anything else related to estate planning or probate, you can talk with us over the phone for free by going to estatemeeting.com. Okay. Had a client in today to do a will signing, and in the course of doing that, learned that she believed that maybe she had added her son to her real estate via quitclaim deed. Quitclaim deed is basically just a deed that says I'm not providing any warranty as to title, but I'm giving away this interest that I have in this property to this other person. Okay. I know, I just went all straight lawyer on you right there. Basically just a way to transfer your property to somebody else easily. And she did this because she thought that she would be able to, or that if she died or when she died, that her son would then just take over the whole property. That is an easy way to transfer the property to him. I am here to tell you today that that it might not work the way that you want. It really depends on the specific language of the deed. But if you don't do it right, it won't work anyway. And B, if you do it that way, you are opening yourself up to a bunch of potential problems and missing out on some very specific tax benefits. All right, let's start at the beginning. If you quitclaim your real estate, half of your real estate, for example, to one of your kids while you are alive, at that point in time, that child owns half of that property, which means a few different things. They could sell their half to somebody else. They could have to go into bankruptcy, and that half could have to be sold off. It could be lost, right? Those proceeds, there could be a lien put on the house, so that whenever it's sold, that half is going to go to somebody you don't want to go to. They can also potentially, depending on how much equity is in the property, get a home equity line of credit and run the credit up, right? There's all kinds of different interesting, crazy, terrible things that can happen by putting somebody on your real estate that really shouldn't be there. And then here's the other thing too. When you die, if the deed itself does not have very specific language where you are owning it jointly and severably, there's a language involved, then when you die, there's a good chance that the half of the property you gave to your child will be owned by that child, and the other half, the half owned by you, will still have to go through probate to get distributed or get transferred over to whomever it's supposed to go to. On top of that, when you give away property while you are alive, it's deemed to be a gift, and that gift does not allow for a step up in tax basis. So if you have a property and you bought it for $100,000, let's say, and now it's worth $1 million, if you give it to your child while you are alive, the child is going to take that property with a tax basis of $100,000, meaning if they sell it, at least that half, okay, we're going to get too technical here, they're going to have to pay a capital gains tax on all of that gain, on that $900,000 gain. If you wait until you die to give your child your property, they will take the property with a tax basis of $1 million, which means zero capital gains tax, zero. Okay, last but not least, there is a way to do this very easily. It's called a transfer on death deed. Google it, okay? Take a look at it. I've got other videos talking about it. It's an easy way to transfer your property to anyone that you want without having to go through probate after you are dead, okay? All right, that's it. Bad idea. If you're, however, okay, I'll say this at the end. But as always, if you like this video, please hit the like button. If you know someone needs to hear this, please share it with them. If you have a question or comment, please leave it. I will answer it. And if you are thinking about doing this, if you have done this, or if you have any questions about this or anything else related to estate planning or probate, please go to estatemeeting.com. You can set up a time to talk with us over the phone for free, estatemeeting.com. All right, that's it, everybody. I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.